from my perspective as an attorney and as an elder law attorney, one of my goals is to try to educate the public as much as possible of the things that I see that people are not ready to grow old with. The documents are so critical, because if we have the proper documents in place, we can handle the financial side of it. As you age, things cost a lot more that you never had to pay for because you can't do them anymore. And one of those things is caregiving. Caregiving, I want to stay home and take care of my parents. That may be a good idea to a point, but you have to have powers of attorney in place so that you can pay their bills. A lot of times the parents from my parents' generation are not willing to share the information with their children. They're still children. And even though they may be bankers or lawyers or doctors or accountants or just really sharp people, the parents aren't going to share that information with them, and it's very frustrating. Few people really have their estates together enough where their assets are listed so that if a traumatic event happens, people know where their assets are. It's always an entertaining experience for a lawyer and an expensive one for the family when we have to chase after and to find where their assets are. We want powers of attorney in place to handle the financial affairs. We want powers of attorney in place to make health care decisions and to access health care information. And we want powers of attorney in place so that we can make choices for them as to where they ought to live. We can't require them where they're going to live. That's not what a power of attorney does. What a power of attorney does is it helps them make decisions or makes decisions on their behalf in their best interest when they can't. Those are durable powers of attorney, and durable means that if I become incompetent or incapacitated and I can't act on my own, then you can act in my place. A power of attorney can only do what the individual can do, and if it's not a durable document, and most of them are anymore, then if it's not a durable document, they can't act because the principal can't act. One of the things that's really important in Medicaid, a lot of times we're dealing with Medicaid and the payment of Medicaid or payment of long-term care benefits with Medicaid benefits. Then we have to have gifting authority to do those kinds of things. Medicaid planning is nationwide, and folks, what's interesting is the number of people who spend down all of their assets in order to pay for long-term care, and you don't have to do that these days. And it's painful when one spouse goes into the nursing home and the other spouse spends all of the family money, not thinking that they will ever go in the nursing home. So what we want to do is we want to avoid the impoverishment of the community spouse, the one at home. We can't do that all the time unless we have the authority under those documents to make gifts of transfers or gifts of property so that we can create trust and preserve the family wealth. In Medicaid planning, often what you hear a lot about is, well, I've made a $10,000 gift or even gifted for tax purposes, so those are exempt in Medicaid. No, no, no. Everything that you transfer to families or anybody in the Medicaid process is a disqualifying event or disqualifying transfer. There is a 5-year clock that if you've given anything away, transferred the house, given away your car, given away even transfers to the church to fund the building association, that's going to be presumed to be a transfer to make you eligible for Medicaid, so you're going to be ineligible for a period of time. So one of the things that we counsel lawyers about is to be sure they understand that for their clients. We counsel clients. We get a lot of referrals from attorneys on how to do this and make folks eligible for Medicaid without impoverishing the family. You can still use trusts, and one of the very special components in estate planning is special needs planning. And I'm guardian for 3 special needs individuals. Those are people who have disabilities. Perhaps their aging parents are no longer able to provide care for them, or perhaps the parents have passed away and left money to their children. Well, those kids are often on Medicaid or receiving SSI because they were never able to work from childhood. And you can use special needs trusts to exempt what the parents have left for those children so that they retain their SSI benefits and Medicaid benefits. That's a really special practice that we enjoy getting involved with. One of the things that folks don't realize is that the parents can create a special needs trust for the child, and in doing so, avoid the Medicaid reimbursement provision. Those are what called third-party trusts as opposed to first-party trusts. If the parents leave money to the children directly without special needs trusts in their estate plan, we can still create a special needs trust and exempt those resources, but the trust has to have a Medicaid reimbursement provision in it. Big difference between having to, if you have 3 children, having to reimburse Medicaid for the child share that was in the trust, as opposed to not having to reimburse and letting the other 2 children have the residuary of that trust. So it's a specialized kind of planning. It's a planning that is very rewarding because parents don't realize they can do it. Often the other children that are involved that are left to provide the care, they aren't aware of that kind of planning, that they can take the share that their sibling took from their parents, unaware that they could do it. We can create a trust and preserve money for them, so it's exciting.